Welcome everyone to the next philosophy class from the Metanet Membership Club. We are currently studying the philosophy of law under Dr. Craig Wright, and this month we are studying chapter 2 of the philosophy of law. Thank you for attending and listening. Please leave comments in the comment box below on the YouTube channel. And without further ado, over to Craig.
Okay, so afternoon, evening, morning, whatever it is, wherever you are. So today we're going to continue with the philosophy of the law. I'm going to recap a little bit, and we're going to discuss some of the areas in the sort of topic of judicial powers within the framework of a democratic or republican society. In this, our focus will be on the philosophical underpinnings of judicial authority, the balance of powers, and the implications of judicial activism. So we're going to explore these concepts through the lens of libertarian philosophy, more in the true sense of what it has been, not what that term's been hijacked to. Some of the areas look at areas that align with someone like Robert Nozick or Hayek. And this perspective is more on a minimal state and the protection of individual rights, something that has been eroded quite a lot in recent years. So in this, the role of the judiciary in a minimal state, I would, like many others, argue that the judiciary plays a crucial role in upholding the functions of protection against force, theft, fraud, and the enforcement of contracts. Judges are tasked with interpreting and applying law to protect individual rights and to ensure justice. Their role in such a state is to ensure that disputes are resolved, to interpret the law as it's been put down by the people in society, and to impartially apply it equally across anyone, blindly. That's why we have blind justice. However, we also need to think about, the limits that the judiciary operates within. And the expansion of judicial powers beyond these functions threatens individual liberty and puts a risk of transforming the judiciary into a tool of coercion. We've seen that starting in some places, like in Israel, for instance. The justice system over there has changed quite a lot in the last 50 years. So what we need in a, functional Republican type system, a republic, a system designed with a balance of powers, is a judiciary that respects the boundaries of its authority, refrains from activism, and adheres to the principles of judicial restraint. So in this, what we're looking at is emphasizing that we have a principle that judges should limit the exercise of their own power. They should interpret the laws as they are written, adhere to precedents, and avoid making policy decisions. This approach we'll find aligns with the minimal state and provides something that doesn't have overreach and allows people to be free, as it prevents judges from overstepping their bounds and encroaching in legislative and executive branches. By contrast, in systems where judicial activism occurs, judges interpret laws based on their own personal views, societal trends, or perceived moral obligations. Even when we take the idea, as in Israel, for instance, people argue they're basing it on societal trends, then it's an interpretation by the individual. You can't really sit there and say, this is what society is doing. You're interpreting and putting your own moral slant on things. So some will argue that activism is necessary to address injustices, to adapt to changing societal norms. They will argue that it possesses, significant risks, but these can be balanced. And in this, an activist judge can undermine a democratic process by making decisions that really should be left to elected representatives. And when we're talking about this sort of structure, changing norms change in a democratic society because, as we've seen in Britain, governments get voted out. And when a government doesn't act in, the will of the people who voted in, they find that they're no longer a government. In this, an activist judge can also introduce subjectivity, inconsistency, and bias into a legal system. So if we take, for instance, the landmark case of Brown versus Board of Education or Roe versus Wade in the United States, we see the far-reaching impact of judicial activism. In those decisions, they addressed significant social issues, but rather than leaving it to the people, the individuals in each state, the voter, then the judges have taken it upon themselves to fix what they see as a problem. This highlights the tension between judicial authority and democratic governance. Activism can drive social progress, but just because you can do something doesn't mean you should. And it must be tempered, as a result, by respect for the law and the limits of judicial power. So this is a part of the experiment that happened in the US of A. We would see that the balance of powers that were created between a judiciary, a Senate, a Congress, for instance, balance. Each is divided so that the executive, the legislative, the president separate to the Congress, and the judiciary form a basis that balances power and provides, in a way that we've talked about in some of our earlier philosophy lessons, the fundamental principles that underlie a functioning democracy. The balance of powers between the legislative, executive, and judicial branches ensure that no single individual branch wields excessive authority. This is how we protect individual freedom. This is how we maintain a check on government power. Now, while it's true that many will argue that this also stifles development and growth, just because you want something doesn't mean it should happen. And most of the people saying this are people who can't get enough people in society to agree with them or can't get the money themselves. So the judiciary's role within this balance would be to interpret and apply the law impartially, to ensure that the legislative and executive branches operate within their constitutional limits. Judicial review is a critical function. It allows courts to assess the constitutionality of laws and executive actions. It also needs to be noted, however, that this power must be exercised with caution. Judicial overreach can disrupt the balance of powers. If so, it undermines the legitimacy of the legislative and executive branches. So to maintain balance, a judge or the justice system itself must respect the roles of the other branches. They should apply laws based on legislative intent, not personal interpretation or belief. Judicial decisions should be grounded in legal precedent and established principles. It should be providing consistency, predictability in the law, and in adherence to these principles, the judiciary will uphold the integrity of the legal system, protecting the rights of individuals. So the implications of judicial activism they're quite profound. When judges take an activist approach, they risk undermining the democratic process and eroding public trust. The public trust in the judiciary vanishes. So activism in judicial overreach leads to a system where judges impose their views on the law, bypassing the will of the people who created the rules and through their elected representatives. In this, judicial activism can create uncertainty in the legal system. That makes business and trade less likely to succeed. It limits merchant activity, and decisions based on personal views or societal trends are unlikely to be consistent. This again leads to unpredictability in the application of the law. Unpredictability undermines this rule of law. Individuals and businesses can't rely on a single framework, and as such, people move to other more stable jurisdictions. One of the reasons that Britain, for instance, became the heart of banking for many years wasn't just that they had a good navy, it was that they had a common law framework that allowed people to basically know and predict what would happen. So when you structured a contract, you could create something where you knew what the outcomes would be in advance. So judicial activism can concentrate power in the hands of a few unelected individuals. This concentration of power is antithetical to the principles of a fair state and the protection of individual rights. Through this, we see a risk of transforming a judiciary from a neutral arbiter, something that, well, is a judge of the law, into a protective or proactive agent of social change. Here, judges act as policymakers rather than interpreters of the law. So to mitigate these risks, it is essential that we uphold the principles of judicial restraint. Judges should interpret laws based on their plain meaning, adhere to precedents, and avoid making policy decisions. In doing so, they respect the democratic process, maintain public trust, and ensure the stability and predictability of the legal system. So overall, one of the reasons that we look at all of these topics and we try and learn, well, the fundamental areas that go behind it, the idea of natural law, common law, etc., is so that we can argue this properly, so that we can actually be part of a working democratic society. So today, we're going to explore the fundamentals of misunderstood areas of legal philosophy. We're going to go further into depth how natural law and common law shape our legal system. We're going to look at philosophies that guide the judiciary in interpreting and determining laws, but ensure the integrity of the rule of law and democratic governance. So natural law, as I stated last time, is rooted in the works of Aristotle and Aquinas. This asserts that law is intrinsically connected to moral principles discovered through reason. We have a system that has, in the West, profoundly influenced the development of human rights and ethical standards. Alternatively, common law, which, as we stated, developed in medieval England, relies on judicial decisions, stare decisis, etc., precedents, and it ensures consistency and adaptability through the principle of stare decisis that we mentioned and talked about. Together, these philosophies offer a comprehensive framework for understanding and developing a legal system that is just, adaptable, and responsible to the needs of society. So, to really go over everything briefly again, the origins of natural law started with Aristotle. Aristotle posited that natural law is rooted in the inherent purpose or telos of human beings. That is to achieve the good life through the exercise of reason and virtue. Then Thomas Aquinas in the 13th century developed this idea further. Aquinas integrated Christian theology with Aristotelian philosophy, arguing that natural law is part of divine order and that human-made laws should be derived from and consistent with natural order. This perspective holds that laws align with moral truth, thereby laying the groundwork for fundamental human rights. So the development of common law through the medieval period, etc., was shaped by judicial decisions and precedent. After the Norman conquest of 1066, we have the creation of the King's Court, the issuance of royal writs, and the developments that followed helped establish a coherent framework based on case law. The Magna Carta of 2015 further concentrated and cemented the importance of individual rights and due process, and it laid the foundation for the rule of law and the protection of liberties within the common law tradition. Now, many today argue from an anarchist approach that we don't want law, etc. But at best, all we can see out of that is might makes right. The only answer, when we think it through, if we don't have laws and systems, is a system where the person with the biggest gun wins. So the alternative is, of course, we can go too far and we can have laws that only apply for a legislative purpose. Hence the distinction between natural law, something based on a moral basis, universality and human nature. Morality in natural law involves objective moral principles that are inherent in human nature and which can be discovered through reason. These principles are universal, unchanging, and provide a standard for evaluating the justice of laws. Human nature is fundamental to this theory. We're not perfect. There's nothing saying that all people need to be sort of beyond and above what they really are. It's not setting a standard that nobody can achieve. It's the average normal person. And what would they think if they were doing right? It's the rational capacity of us humans to understand that moral order is central to natural law and to apply this by emphasizing the role of reason and to find principles that allow for the common good. So common law really builds upon this and integrates it. The way that the two systems applied and built together, well, allowed judges in common law systems to take responsibilities that were quite significant in interpreting and applying the law, and then, well, building a system that could be applied constantly, consistently, and fairly. This, as I noted before, requires that legislative intent and previous judicial decisions are understood. The broader legal context helps judges clarify the law, contributing to the evolution and relevance as it applies to contemporary issues. Even here, law will change. The distinction is it's not based on the belief system of the judge. It's based on the overall sort of way that society has moved, the implications of changing legislation, and much more. So, stare decisis and ratio decidendi. Well, stare decisis dictates that courts follow legal principles established in previous decisions, precedent. This, again, I'll emphasize to say consistency and predictability. Ratio decidendi, the core reasoning behind a judicial decision, forms the binding element that guides future cases. Why did I apply this? Judges use various interpretive methods, including textualism, that focuses on the plain meaning of the text, positivism, which considers the broader purpose behind a legal rule, and contextualism, that examines the broader legal and societal context. And in this, we basically structure something that shapes public policy, hopefully expands individual rights, but also through this addresses social issues. We focus people on doing the right action, on building a society that is best. An expansive view of the judicial role will include, thus, a focus on protecting minority rights. So in the implications of where this goes, activism can lead to legal reforms, and some will argue address systemic injustices. However, in doing this, if not applied correctly, we have the reach and the erosion of the rule of law. Critics here will argue further that jurisprudential consistency and reliability are undermined. This will potentially infuse personal bias into the decision-making, and the tension between these, well, makes it less likely that a democratic society can balance legal adaptability and doctrinal stability. In that, the separation of powers, the ones we mentioned, well, in the writings of Montesquieu, come apart. They fall apart and don't actually enable us to act and develop a system of, well, effective government. Rather than being citizens, we become subjects. As Montesquieu noted, dividing governmental power amongst legislature, executive, and judiciary prevents the concentration of power, which safeguards liberty. Not everyone wants liberty. Freedom is something that's hard. We have to fight for it. But to do so, we have to understand what it is. So the division of power is crucial in any modern legal system. Without it, we can't maintain accountability or transparency. Judiciary interprets and applies laws, the legislator creates laws, and the executive enforces them. That's the distinction. Understanding this balance of power between the branches is essential if we want a functioning democracy where we avoid potential conflicts. So to maintain a balance between judicial interpretation and legislative process is vital if we want to, well, maintain a democratic governance system. If we want to enhance legislative clarity, precision can reduce judicial intervention and limit ambiguity. When we have a statute that has been mucked around with before it's been there. It's quite frequent that we have ambiguous worded statutes. So by improving legislative accountability, these mechanisms also ensure that elected representatives remain responsive to public concerns. And that's part of what judges also do. Codifying judicial powers within constitutions provides clear guidelines for judicial interpretation and review, and delineates the boundaries between judicial and legislative authority. So establishing judicial councils or oversight bodies can also enhance judicial accountability while preserving judicial independence. So in this, we're trying to form a system where we create just laws. We protect the moral rights, the rights of the individual, and the values that we find to be inherent in human nature that I said, and everyone else that I'm going to mention, has argued are discoverable through reason. While some people will argue reason is not good enough, reason itself isn't a scientific process. It's logical, it's structured, but it's different to science. So this is something we need to think about as well. Values undermine reason. And the reason we have values, well, arguing they're just there because that's human nature, well, we are human. So to get into the essence of natural law, we have to go back to the historic roots, as I've said. We touched on Aristotle. We've done that a few times throughout these lectures over the years. And the concept of moral order. Moral order, ethics, virtue, there's something we strive for. Virtue would be best analogized as a muscle. The more we work it, the better it gets. It gets stronger. The same as if we have vice. If we want to work on stopping doing something, smoking, for instance, that we don't want to do, then we have to work on doing it. It doesn't happen naturally. Now, when we think about what we're trying to do, we are going to always have the problem that everyone thinks they know best. It's very simple. Everyone thinks they can rule the world. Everyone has a solution. Everyone has answers. And the problem is, maybe they do. Maybe their version of the world works for them, but it doesn't work for everyone. And when we say fundamental human rules, fundamental human values, fundamental human concepts, not all of them will be treated the same by everybody. There might be some underlying areas, but even the mix or the balance in any of these principles is going to, well, differ. Some people want more order. Some people are happy with less. And in doing this, we need to find a system that balances these differences and allows a harmonious way of arguing points. Sometimes people believe things will work, and they might work in the short term, but over the longer term, they won't. And this is part of the reason why we have such a system. So understanding a philosophy where we balance power allows us to ensure that people, well, can have an uninterrupted, for the most part, life when they're not interrupting other people. So to go through more of this, what we're going to really start to think about is how do we balance the rights of different individuals in society? And that's really what the heart of the philosophy of law is about. The historic context here is if we have many people, a polis, a society, a city, a country, a nation, a state, how together do we all work in a way that works, where it's not just self-interest, where we're not just going out for what we can do at any other cost, where it isn't falling into a Hobbesian world where we grow basically and take anything we want, where we ensure justice and fairness. So in all of these things, the development over the years has always been, how do we create a society that balances, well, what one person wants with another? How do we create a society that protects the right of someone who, well, may not be liked, but maybe they've got a contract. But just because we like them shouldn't mean that we choose them. How do we, well, choose between the con man who's really nice, who everyone likes, who is personable, and the person who's a curmudgeon that people hate? All of these things are part of the common law jurisdiction. It's part of how we choose and why. And these are forming the precedent that underlines all these systems. So in going into why, we need to think more into, well, what are we trying to achieve? And again, if we want a system where we have a prince, where a demagogue tells us what we're doing and builds it, fine. If people want that, then that's their choice. It's not my choice. But in doing this, it is a society that may work. And princes achieved many things that republics don't, and vice versa. If we think for a moment, many of the great temples, many of the great artworks, etc., were built under, well, princes, people who want something done. The pyramids, they wouldn't have been done ever, I believe, by a republic government. But equally, we go back to, well, the heart of Italy in the Renaissance, and the humanist system there was republic. So republics can achieve great things, but it doesn't mean they will. So the consequences of allowing judges to determine law. If we allow a judge to determine law, we have a challenge to the foundation of the democratic process, as I noted. And in doing this, well, it erodes democratic legitimacy. Democratic legitimacy is rooted in the principle that laws should be created by the representatives elected by the people. When judges who are appointed rather than elective assume a quasi-legislative role, this foundational principle is compromised. Judges, by virtue of their positions, lack direct accountability to the electorate. Unlike legislators, people who, as we just seen in the UK and even in France, who are periodically, well, seek re-election and must remain responsive to public opinion. And as in the UK, well, if they don't, they find they're no longer in a job. Judges are insulated from such pressures. The insulation here creates a detachment from the values and preferences of broader society. So while they have moral values and they think that they're going to be taking on the societal values that they're meant to represent, they won't. The concentration of power, of lawmaking power in the judiciary, undermines the legitimacy of the legislative process as well. The process of electing representatives and the subsequent debates, compromises, negotiations are essential components to a healthy democracy. I know many people argue that all of the debates, the balancing, the flip-flopping on promises, it undermines things. But the reality here is it's balancing, well, one side against another. Anytime we have a judiciary intervene in that, then it's going to change it. And that process is a valid part of democracy. A healthy democracy needs those compromises. So when a judiciary overrides or reinterprets laws created through this process, they effectively bypass the democratic mandate. This can lead to a situation where laws reflect the interpretations and preferences of those few unelected individuals rather than the collective or the will of the populace. So the accountability deficit then results. The principle of accountability is central to democratic governance. Montesquieu covered this. We covered this in our, well, a few years ago. And elective officials are accountable to their constituents and can be removed from office if they fail to represent the interests and values of their voters. Case in point, we just saw it in Britain. If you fail to take people into account, they won't vote for you. The judiciary, on the other hand, well, many times we see a lifetime appointment without being subject to electoral pressure. This creates a gap in accountability. So without a mechanism of election, judges are not readily or directly answerable to the public for their decisions. There's a reason for this, but also a problem with it. So the direct lack of accountability can lead to judicial decisions that are out of step with public sentiment and societal needs. The potential for judicial overreach becomes a significant factor as judges may feel emboldened to impose their interpretations and values without the fear of electoral repercussions. Now, in England, the fact that the Tories had been in for so long led them to believe that they're just going to do whatever they want. They stopped caring about what the feedback was. Old Boris there went off and had parties when everyone else was locked away, and others have just not cared. And the problem with this, well, we've seen it, but it's also a built-in solution. It might be only every 4 years, 3 years, etc., but it happens. And a backlash occurs. And eventually, where there's an election, well, we don't have the same people anymore. And you can argue, well, more idiots that are like the other ones. But that just means we're not being involved ourselves. And the reality here is, yes, but we've sent a message. And all of these parties are going to have to do a lot of thinking, a lot of work to change. And that's what elections do. So the legislative process is characterized by debate, a robust debate usually, negotiation, compromise, as I've mentioned before. And these come because of, well, scrutiny, rather rigorous scrutiny over time, that is applied through the electoral process. Judicial lawmaking, in contrast, lacks that public engagement and transparency. So judges take on a lawmaking role where the rich democratic deliberation that typifies legislative processes is curtailed. This shift can result in laws that do not fully encompass the various and diverse perspectives of the values of society. So in this process, in its nature, we find a less transparent way of doing things than a legislative proceeding. So the lack of public participation and scrutiny in judicial decision-making can lead to the perception that the judiciary is acting in a manner disconnected from the public will. That itself builds up resentment and, over time, backlash. It won't be backlash when what we see in an election because we don't have them. But it leads to other issues. When people become frustrated, we're starting to see that in Europe and France, for instance, where we start seeing, well, people go to the street and doing things outside of the law when they no longer have faith in it. So judicial supremacy opens the door for judicial activism. In this, judges use their positions to advance the specific ideological agendas. Now, this is argued by some, such as the Rawls of the world, who I haven't covered, but John Rawls is a philosopher. Nozick is probably his counterpoint. Argue that this corrects legislative and executive abuses. But it also risks politicizing the judiciary and undermining its impartiality. The unbiased arbiter role of the judiciary is crucial in maintaining public trust in the legal system. So when judges are perceived as political actors, that trust becomes more and more eroded. So to look at the philosophical analysis and basis of judicial supremacy, we have to think about the complexities of, well, a system that through legal positivism and natural law offer a contrasting critique. So legal positivism emphasizes the separation of law and morality, argues that the legitimacy of law comes from its source rather than content. From this perspective, judicial supremacy is problematic because it allows judges to create law based on their interpretations and values rather than strictly adhering to legislative intent. Legal positivists assert that judges should apply the law as written without infusing their personal beliefs or moral judgments. Judicial supremacy, by allowing judges to shape law, undermines the positivist idea of law as a set of objective rules created through the democratic process. Now, the alternative is the natural law critique. The natural law theory posits that law is inherently linked to morality and that unjust laws are not true laws. From this viewpoint, judicial supremacy can be seen both as a strength and a weakness. On the one hand, it allows judges to correct unjust laws and uphold higher moral principles. On the other hand, it concentrates too much power in the hands of judges whose interpretations of morality may not align with those of the broader society. Natural law theorists caution that while judicial intervention is sometimes necessary to ensure justice, unchecked judicial supremacy can lead to moral authoritarianism, where the moral views of a few judges override the collective moral judges of the community. So, in an examination of democratic legitimacy and understanding a risk of judicial supremacy, we need to analyze the concept that we've just talked about, the roles of the elected representatives, and compare those to the appointed judges in the lawmaking process. So the role of elected representatives, well, they're conduits of the popular will. They're a representative. They represent a community, or at least they're meant to. In doing this, they play a central role in democratic legitimacy. Their primary responsibility is to create the laws that reflect the preferences and values of their constituents. You can argue that they don't. But when they don't, it's usually our problem. We, as the constituents, haven't acted. We haven't voted. We haven't become part of it. We haven't become a magistrate. We haven't, as in not part of the judiciary, but as in a Roman idea of someone engaged in a republican society. The process involves public debate, scrutiny, amendment, ensuring that laws are subject to rigorous examination and consensus building. And this process together creates the foundation that we build a democratic society upon. The electoral process provides the mechanism for accountability. The representatives who fail to act in the public interest become, well, no longer a representative. I'll emphasize this again. The current elections that we've just had in the UK demonstrate what happens when the public interest isn't followed, when you think as a representative you know better. Well, you end up being voted out of office. So you're there for a purpose. You're there to represent. Judges, when they're appointed on their legal expertise and judicial temperament, are tasked with interpreting and applying the law impartially. They have a role to ensure that laws are enforced fairly and consistently. They're not supposed to succumb to political pressure. However, when a judge assumes a lawmaking role, they can operate outside of the direct democratic process. Their decisions, whether they're grounded in legal reasoning or not, are subject to the same democratic checks and balances of those made by elective representatives. This shift leads to a disconnect between the judiciary and the democratic will of the people. So the balance that we talk about of balancing judicial and legislative powers, the challenge is to strike that balance between the judiciary and the legislation, the legislative branch, the judicial branch. While judicial review is necessary to safeguard against legislative and executive overreach, judicial supremacy risks undermining the very democratic principles that it's designed to protect. To mitigate this risk, we need to consider a number of measures. So, firstly, clearer legislative drafting. This goes back to, well, hopefully having better representatives. And that goes back to us as constituents, as making sure that we allow and select the right representative and that we're engaged in the debate. We don't just sit back and think, well, politics is something I watch, but we get involved with it. So the approach here is to improve the clarity and precision of legislative drafting. When we have ambiguous laws, these lead to judicial interpretation and subsequently judicial lawmaking. When we have people draft clearer and more precise laws, the legislators can reduce the scope for judicial interpretation, ensuring that the intent of the law is more faithfully executed. When there's no room to interpret, then judges don't. Next, we have strengthening judicial oversight. The next measure is to strengthen the legislative oversight of the judiciary. This includes regular reviews of judicial decisions and the establishment of mechanisms to address potential overreach. One area people don't think about is there are actually built-in review functions within the judiciary in common law nations. For instance, in Britain, a magistrate goes to a court with a judge, goes to an appeals court, goes to House of Lords, etc. There are multiple levels, and the judiciary has its own system of checks and balances. And while that isn't always as easy, some of these involve appeals and multiple levels of judicial review. So appellate review, transparent appointment processes, these are all important. And to do these correctly, we prioritize merit and impartiality. Bias. When a judge bias, he should be, or she should be, well, held accountable for that. So the risks of judicial supremacy are significant. But overreach into the realm of lawmaking undermines the democratic legitimacy and accountability of our system. A careful balance needs to be struck if we want to ensure that judges can check legislative and executive abuses and stop them happening without assuming a dominant role in the lawmaking process. We can protect the integrity of legal systems. So these are the areas I want you to think about this week. Now, as we've gone over this, I've covered a number of areas. I've covered natural law. I've covered Aquinas. We've covered him in the past. We've covered common law and the comparative analysis of the, well, intersections between law and the implications. We've also gone into a few extra about with these theoretical now. I want you to start thinking that these are tools. I pointed out that what we have is a balance between different values. It would be great if we had everything we wanted, but we're not in that system. If we had a system where no matter what, everything was there, then no one would need to work or strive or do anything or create. It would just be given to us. Personally, I don't want to live in that system. I like a system where we have to strive. I like a system where we have to build. And when we think about the distinction here, the problem is, well, we might have principles, but all principles need to be examined because they're all in conflict. When we choose these things, we need to think about what we value most at a particular time, what is worth more than another. It's not just a three-body problem. If we're thinking about the various different options, then we're balancing many, many different, well, individual virtues. And even the choice of virtues themselves, and what we call a virtue, is something comparative and something that different people will choose differently, describe differently, contrast differently. So the ones I value probably aren't the same values to another person. And in that, that's how we make a society. If we want it to work, we need to match these areas. So our theoretical framework really comes down to thinking about how we create a system that allows us to match all of this, how we put the core aspects that we find well, the heart of human nature and allow us to, well, build a system that is fair. That doesn't mean we get what we want. It doesn't mean that everything works the way we want it, but as fair as can be. One that maintains order without stifling innovation, one that protects individual rights without crushing society, one that promotes social justice. All of these are in conflict. So if we take Jeremy Bentham and we remember he said the primary purpose of law is to maximize overall happiness and well-being, we have to remember, what is that? What is overall happiness? We go back to Aristotle, Eumendia, the concept of, well, a flourishing life. It's not just pleasure now. If we think about the rights-based theories, such as those influenced by Immanuel Kant and later scholars, then the protection of individual rights and autonomy is a fundamental aim of law. Yet these are very different choices and very different principles. So as we draw towards the end of this lesson, what I want you to think about as we're starting, well, understanding these different areas is we're trying to figure out what the goals of a legal system are. And your role as a constituent in a democratic society is figuring out those goals. This is something that most people don't actually understand. Your role isn't to add guidance to a prince. Well, I don't know, maybe there's some listener out there who's part of a communist society or part of a dictatorship and effectively is in a system that gives guidance to a prince, but I'm not. Even when I'm visiting one, I'm not part of one. And as such, I still like to think of, well, a republic. Even if it's a constitutional monarchy, then I'm looking at a republican system that has a division of powers vis-a-vis Montesquieu. So all of these different things about the fair allocation come down to it. And the reason we cover this, the reason we go into the purpose behind understanding law, the reason we go into logic, is so that we can debate all of these areas correctly, not by force, not by substituting what is valuable, not by subterfuge, not by deception, but openly and honestly. So at this point, I'd like to open the floor for questions again. And I'd like you to, having hopefully had a bit of a read of these different areas, think about what the distinction of common law, natural law itself means to you.
What are the two principles of law that form the basis of what Craig has been talking about? Can anyone please raise your hand and answer that? Come on, he literally just said it.
Do you mean the two types of law, like natural law and common law?
Yes.
Yeah. So
Can you expand upon the natural law? What is meant by that?
so natural law is law seen from a moral standpoint. So or if you are to go the Aquinas route, more of a divine standpoint. So what is it to live or what is it to be a moral human and to respect other people, whereas common law is more about the process, about building a foundation of precedent upon which you can judge, cases that are presented within the judicial system and have consistent rulings. And so they're two different ideas, but they complement each other quite well.
I'm going to go back. I'm going to go back one step a second and ask another question related to the natural law, the moral basis, as you just said. I'll see if someone else can answer it. Otherwise, I'm going to come back to you, Brendan, because this is all for the audience as well. Can someone please describe how we define moral law? How do we reach that moral standing?
With the natural law?
With the natural law, yeah.
Well, it's supposed to be like the natural order of things. And then you're supposed to like use your reason to discover how to articulate it, but it's natural order and sort of, patterns in nature that you can see. Sorry, I'm at the wholesale market, so it's kind of loud, but
that's okay. But there's one thing I'll try and point out that is a little bit, complex for people. One of the areas that we should be aiming to do is accept, being shown to be wrong, and be happy when people point out logically through reason flaws in our argument. And we should, basically embrace that and change from it. So if someone demonstrates that we are wrong, if we say 2 + 2 = 5 and they prove to us 2 + 2 is 4, then we should be happy to accept that. One of the problems, of course, is we haven't been educated in the right way, and society doesn't do that terribly well anymore, such that we're happy to embrace, error and correct it. So I'm wondering if anyone has read Pufendorf, the German philosopher and jurist. I mentioned him in chapter 2 on duty of man and citizen. He writes about the social and contractual nature of law. Basically, it's the difference between rights, duties, etc. We have mutual obligations to promote the common good. Unlike many people who say human rights and just say it's innate, the distinction here is that it comes with a cost. You don't just get human rights and everyone has to do everything for you. You have human rights because you're part of a society and you have a duty back to that society. You have mutual obligations. So on that, not that I'm a fan of Rousseau, but that's really part of the social contract as well. Just he took it too far. I'm going to leave you to have a bit of a chat about all these areas. The other areas that I talk about in the area to Wright, like Hugo Grotius, the Dutch philosopher, and the different areas of common law, and see if you can actually work out some of your own distinctions in values and beliefs. Remembering that if you're open and honest, then you shouldn't be upset with what other people are saying here. You should, understand that you're going to have different values and know that, that's what competition's about. So I hope you all have a great night.
thank you.
Thanks very much, Craig.
Thanks, Craig.
All right.
Thank you.
Thank you.
All right. Till next time.
See you next time. I find this stuff really, really interesting, and I'm looking forward to the next chapters. I think this type of education is something that is really missing in schools today. And I think the way that Craig has framed it in his document is actually really great, and showing that the overall framework of the law that we have today is based on these kind of two intertwined systems one a moral system and the other more of an operating system, a set of processes and ways of building the framework that we use to judge right and wrong in society is very interesting. And if you look at the great if you look at the great countries in the world today, and like Britain, United States, they all kind of use these kind of these two sort of systems together, but you can also see that it's being subverted. And so, really, natural law is being pushed out in favor of omnibus law. So these huge law packages that come in, which are just thousands of pages long, where nobody can really ever have a chance of reading through the whole thing or knowing what's in it. And in fact, the laws are passed in such a way that even the people voting on them have no chance of ever being able to comprehend the totality of what is being voted on. And so to me, that is a real moral problem. And if you go back to the idea of natural law, we can actually make the argument that those laws should be struck down. They're not just, they're not correct. They are typically designed to push the power up into the hands of a few rather than leaving it in the hands of the people where it is meant to be. So to me, that is probably one of the biggest fights we're going to have over the next several decades, is trying to bring control of lawmaking back into something, or not control, I should say, but bring the process of lawmaking back to something that the common man can easily comprehend. And I'd actually be for a system where, rather than just allowing anything to be passed as a law, 50,000 pages of, just everybody chucking whatever they want on top of it, it should really be that within that entire legal framework, there's a fixed maximum number of laws, and not even a big number, maybe like 50, and that those laws are actually limited in size, and so such that they have to be able to be read aloud within like a period of 2 hours. And so that when they actually go through the process of voting, somebody actually stands up in front and reads it out. And then everyone can talk about it. And because the way they're doing it at the moment, these so-called laws that are getting passed are just absolute shit. They're not laws. They're just land grabs.
There's Europe and Brexit, right? I'm really pro-European, really pro-Europe, but I am also pro-Brexit. And it's one of the key reasons why the whole Brexit thing happened, because the laws being created by the Euro Council was basically eroding the laws in the UK. And I think people had basically had enough. Though apparently the new government wants us to get back into Europe, so it's all going to be undone if he gets his way. But that's a discussion for another time. I'm going to say, we won't do an after class discussion now. What I will do is set an after class discussion for middle of a month, so that we've got something else to do prior to the next thing, so we can like divide it up throughout the month, and then that way there's lots of pre-warning, and we can just have like 1 hour sessions again, like 40, 60 minutes, rather than having a 2 hour long session, once a month. It'd be split, which I think will be easier for everyone.
Idea.
Yeah, it's good.
All right. Thanks, Joel.
Okay.
Thanks so much.
I'm going to